I'm Catherine here in Washington, and we're coming to you now with some breaking news. The U.S. Supreme Court has decided to take up former President Donald Trump's appeal in the Colorado ballot case. The state Supreme Court disqualified him late last month, citing the 14th Amendment to the Constitution. It bars those who have taken an oath and participated in or aided with an insurrection from holding office again. Oral arguments are set to begin February 8th. CBS News legal contributor and Loyola Law professor Jessica Levinson joins us now. Jessica, let's just start with the pace. Republicans from the state of Colorado asked the Supreme Court to hear this case in December, and they've already agreed. Does that tell you that we're on a fast track?
As we know, the big cases typically come out at the end of June, but time is of the essence here. There are primary ballots that are going to be printed. And even more than that, we need to have clarity on this question of whether or not the front runner for the Republican nomination is in fact qualified to be president of the United States, or if he's legally barred from being so, because that will change the dynamic of the race, obviously, deeply. As we move into the primaries, as we move into Super Tuesday.
So let's take that a step further. What are the arguments on both sides before the court?
So I think the arguments that the former president should be disqualified are essentially what the Colorado Supreme Court said, which is that Section 3 applies if there is an insurrection. They said there was an insurrection. If the former president gave aid or comfort to those who engaged in insurrection, again, they said he did. If the office of the president is an office that is covered by Section 3, the Colorado Supreme Court said yes. If you do not require a conviction of aiding or abetting an insurrection prior to applying Section 3, and again, the Colorado Supreme Court here said that's not required based on a plain meaning of the Constitution. On the other side, I think you have both legal and policy-based arguments here. So on the other side, we have the former president saying, there wasn't an insurrection. I didn't give aid or comfort to those who engaged in it. You didn't convict me of that. That Section 3 is not self-executing, that Congress, in fact, has to act before it can be applied, and that Section 3 doesn't apply to the president. So they really are, in many ways, mirror images of each other, with the addition of the former president saying, and don't take this away from the voters. Let the voters decide.
And just to expand on the legal arguments, isn't there a question also of due process in this case?
So that certainly is something that those who support the former president and others have said, can it really be up to the Maine Secretary of State, for instance, to make this determination? I think the response is there was actually process. In the Colorado case, there was a 4 or 5 day trial. In the Maine case, there was a 1-day, I believe, administrative hearing, and now that case is being appealed through the court system. So the idea that one official in a state is just of his or her own volition looking at the Constitution and making a determination without hearing evidence, that, in my view, is not based in reality.
Jessica Levinson, thank you for your analysis on this breaking news.
Thank you.
For more, let's bring in CBS News campaign reporter and attorney Katrina Kaufman. Katrina, what's your view on the challenge for the Supreme Court and how it could split or be united in this case?
I mean, this is a huge issue for them to take up. And I think, there's a lot of legal scholars that say there is real veracity to the Colorado Supreme Court's decision, the way they've applied Section 3 of the 14th Amendment that could really appeal to the, originalist conservative justices. But at the same time, they really might not want to wade into this political question. And it's possible that they'll determine that this is something that really has to be implemented by Congress.
And just to expand on what Jessica was saying, what's your view on a decision with the 14th Amendment and how that could create a national standard or national consensus?
On what their decision could determine for the nation?
That's right. Yeah, it's setting that bar basically on a national level.
I mean, my understanding from talking to experts in this subject is that they'll likely try to make a decision that's going to apply nationwide. There are so many challenges being made across the country. Even just yesterday, there were 2 more. There was one in Illinois. There was one in Massachusetts, and these are clearly going to continue. So if they don't make a unified ruling, then more cases could get escalated to the Supreme Court. And as we've seen, they already have a very busy docket coming up. So I don't think they want that to happen.
So what I'm hearing you say is you have a sense that the Supreme Court was trying to get ahead of this issue, that they could see that a number of states were lining up with similar legal questions.
Absolutely. I mean, there's already Maine where Trump has been disqualified. That's going to move through the court system there where he has appealed. There's a challenge being considered at the Oregon Supreme Court. And also in both Michigan and Minnesota, they temporarily rejected the petitions, but they said that the respondents could come back before the general election. So really, it doesn't seem like these challenges are going to stop. And the Supreme Court really needs to make a ruling that's going to apply across the states.
And let's just talk about this through a political lens. I think the argument can be made that this is the last place the Supreme Court wanted to find itself in the center of a presidential election. We all know the lessons of 2000 and the impact it had on the standing and the credibility in this country. What are your thoughts?
Yeah, I mean, the last time this happened was Bush v. Gore, and that was a very complicated decision for the court. And I think that they really don't want to wade into this political arena again, but they're being presented with all these cases. I mean, not only this disqualification issue, but there's also the presidential immunity issue, which is making its way to the Supreme Court. They may be presented with Trump's gag order issue as well. And so really, a lot of the different aspects of this election are ending up in their docket potentially, and it's very complicated for them.
Well, what's striking, based on what you've just analyzed, is that the court is being almost given a stress test. I mean, these are issues, constitutional questions, that hundreds of years ago, a foundation or an argument was laid. They're being stressed, though, now in ways that probably the founding fathers could never have imagined, and in particular with the Trump presidency.
Absolutely. And I mean, I think it's really important to note that this Section 3 14th Amendment challenge has never happened before. These are really novel legal questions that we're being presented with and that the court is being presented with.
Is there anything that surprises you about this very quick decision by the court to take the case?
I'm not surprised. I was surprised that Colorado disqualified Trump, to be honest, but I'm not surprised that the Supreme Court is taking the case. I think the consensus is that this is something that they really need to make a decision about to create unity for the country and, across the ballot. Otherwise, we could have ballots with different candidates across the country for the general election. That would really just be chaos.
We're considering a lot of issues here, and I'm wondering, given your reporting on the court and understanding the makeup of the justices, if you had to give us your best assessment and analysis of which way the court could go and how it could split, what would you tell us at this point?
I think that there's maybe a misconception that because a number of the justices on the court are conservative, if you were appointed by Trump, that means that they'll politically lean his way. But really, the arguments that are being made about Section 3 of the 14th Amendment are originalist readings of the Constitution, which is a conservative standpoint traditionally. So I don't really think it's that easy to predict which ways the justices are going to rule on this.
Do you believe it will be important that the ultimate decision will present consensus among the justices, and that will be a real priority behind the scenes, what we won't see publicly?
I think unity would be very important for the country on this. But yeah, it's yet to be seen what will happen.
And just take us through some of the other cases that the court will have to consider that are going to impact directly on the presidential election. We've got the ballot case, right? But there are many others, right, that are stacking up.
Yes, there's the ballot case. Next week, there's going to be a hearing in the Court of Appeals on Trump's claim to presidential immunity, which is related to the D.C. federal election interference case under Jack Smith. So we predict that will very likely also end up before the Supreme Court. The D.C. Circuit is moving very quickly on that issue. And regardless of what they decide, it's anticipated that either side will appeal. There's also a case before them related to obstruction of an official proceeding. And then, as I mentioned, Trump is trying to also appeal his gag order to the Supreme Court. He's under a gag order for the DC federal election interference case as well.
So almost a half dozen cases we're talking about that are really sort of stress testing the constitutional issues and then also the Supreme Court itself. Let's just take a step back and talk a little bit more about the case that the Supreme Court did not immediately take, which was the presidential immunity case. It's going to be heard in the appellate court here in Washington. Going to the appellate court, of course, creates a broader legal record for consideration by the Supreme Court, or they could decide that they're satisfied with what the appellate court finds and they choose not to hear it. What are your thoughts?
Yes, that's very true. I mean, I've heard some people predict that the DC Circuit will decide that Trump is not immune, and then it might give the Supreme Court the opportunity to just let that ruling stand. And basically what happened with this is Jack Smith tried to escalate the case to the Supreme Court immediately because he wants this trial to start. It's supposed to start March 4th right now. That date is more and more in jeopardy the longer that this appeal takes. And the case is also currently on pause while Trump appeals it. But the Supreme Court decided not to take the case. It was really like a one-line ruling. It's unclear what the reasoning for that was. So they moved it back to the DC Circuit. I'll be at the arguments there on Tuesday. And I've heard that Trump will be in attendance as well as this issue of presidential immunity gets debated among the parties.
And help our audience understand something which is, it's sort of a legal idea, which is the presumption of regularity, that when you have a big case with constitutional questions, First Amendment issues, in this case, presidential immunity, you want to strictly go through all levels of the court before getting to the Supreme Court. You want to have a very regular record before it reaches the highest justices in the land. Just help our audience understand why that's standard, and this case wouldn't automatically jump to the highest level.
I mean, well, it's very unusual and rare for cases to make that jump. I think in history, it's only happened 49 times since 1925 that the Supreme Court took up a case without it first going to the Court of Appeals. And always it's on questions of real national importance that are time sensitive, which one could argue did in fact apply in this case. But I think because the DC Circuit was moving so quickly, as you said, it's very important for there to be a decision made at each level of the court. And so, they decided to let the DC Circuit make that ruling first before they decide whether or not they're going to take up this case.
Katrina Kaufman, thank you for your legal analysis during this breaking news. We appreciate it.
Thank you for having me.